This is Dr. Olu Asekun here. Thank you. Please invite your friends, family, colleagues at work as we continue this weekly podcast. Today is another beautiful Wednesday. The good thing is that I'm not in court this morning, so I will have some time to answer some questions and also have time to go over some of the updates. There are lots and lots and lots of updates, even between last week and now. So, I know that last week, as we were about to start the podcast, there were posts regarding citizenship questions. And I did remember mentioning at the time that I've not had time to go over it. So, I have since gone over the release. So, if there are questions right now, so we will appreciate it. If you have questions, send it in through this podcast. I also want to announce that please, if you have questions, we prefer that you send it in live on this platform, because sometimes when people send in questions through text messages, we miss them. So if you are online, if you have questions, this is a live program. So go ahead and send it in. Now, before I proceed to this week's update, I want to conclude on the new citizenship question that we mentioned last week. As I stated last week, the effective date will be October 20, 2025. So any application for citizenship filed on or after October 20, 2025, they will have to face the new citizenship questions. So as far as the new citizenship questions are concerned, it will be you will need to study a total of 128 questions. 128 questions. That's an increase of 28 questions from the current 100 questions. And you will need to answer 12 correctly. 12 of those questions correctly during interview. Now, the officer is not going to ask you more than 20 of those 128 questions. They will ask you a maximum of 20, and the officer will only stop when out of that 20, when you answer 12 correctly or when you answer 9 wrongly. If you answer 9 questions wrongly out of the 20, the officer is going to stop. It means you failed the interview. So if that is the first one, they will give you one more chance. They will reschedule you to come again and try it the second time. And if you don't pass it the second time, that will be the end. So you will have to reapply in the future. But if you answer 12 questions correctly out of the 20, they will also stop, meaning that you pass the civic test portion of the citizenship interview. Okay, so that is that regarding the citizenship questions. Now, let me go to... Yes?
So the people that have already applied for citizenship are not going to face the
No,
tickets?
if your application is already pending, you will still do the test based on the current one. It is only applications that are filed on or after October 20 that will go through the new one. So if you have a pending application, you are going to go through the old one. Now, let's go into today's update, because we have a lot to talk about today. There are new updates. As we probably already know, this administration is not short of new updates, new surprises, new policies every week. So we have a lot to talk about today. The first one we are going to be talking about is that for countries who still play the visa lottery, going forward from this new visa lottery, there will now be a nominal fee of $1 to register for the visa lottery. So if you are going from if you are from a country where the visa lottery is still paid, the registration is no longer free, but it's just a nominal figure, $1. You will now pay $1 to register. So that is the first thing. The second thing that I want to talk about is that the Department of State, they reported that they have revoked over 40,000 visas between January 2025 and now. They released this figure yesterday that as of yesterday, between January 20, when this new administration came into effect, they have revoked over 40,000 visas. So the next thing I want to talk about is that again this morning, just a few minutes before we started this podcast. In fact, this is one of the reasons why we started a few minutes late. They posted this morning in the Federal Register that DHS intend to give special consideration for some professions in the selection of H1B cap selections. So what that means is that they will no longer want petition to be based on first come, first serve, but it will have to be selection based on points. You know, I don't know much about Canadian immigration law, but I do know that in Canada, they have something called point system where they look at your degree and score you some points. So this is what the Department of Homeland Security is trying to introduce into the H1B program. They want to give special preferences to people who are highly skilled. So right now, based on this proposal, I mean, they just posted it in Federal Register, so people are still going to be given 30 days to comment. So after the comment period expires, if they approve it, then it go into effect. So they are saying that, you know, currently there are 65,000 allocations for H1B and 20,000 allocation for applicants who obtain master's degree from an American university. But they are saying now that they want to make it a point system. They don't want to just be every Tom, Dick, and Harry. So they want to limit it to people who have specialized skills, people they consider will be useful to the United States. So if you have maybe a degree in some courses, you may no longer be eligible for H1B. Maybe you have BSc degree in philosophy, for example. I mean, I'm not underrating philosophers. I'm just saying what this new post in the Federal Register signifies. That was just posted this morning, and is the comment period is going to be 30 days. The next thing I want to be talking about is that, you know, that when our president talk about the gold green card, I'm one of those people who thought that that was not possible because I believe that it is only the Congress that can determine who get green card and who does not. And I still have that opinion because, I mean, there are three arms of government. The Congress is the one that makes the law. The presidency, who is the president, who is the head of the executive, is only authorized to implement the law. They don't have the power to make the law. They are only authorized to implement the law. So if the Congress has not passed a law regarding how somebody can get green card, I don't think, this is my opinion, I don't think the president can have that power. However, the president announced, in fact, I think it was an executive order, yes. The president issued an executive order granting green cards to individuals who donate 1 million to the United States and to corporations who donate $2 million as a gift on behalf of an individual to the United States. I don't even know how to explain it. So what this simply means is that I, as Olu Asekun, if I'm a foreigner, assuming I'm not a citizen, I'm a foreigner and I'm rich, I can tell the US government, you know what? I want to give you a gift of $1 million. And then I will now have the opportunity to apply for green card based on that gift of $1 million.
Wait, just the opportunity to apply for green card?
Yes, I will still go over it. This is what the president announced. In fact, not announced, he signed an executive order. But I will tell you what is tricky about it. I think the president probably knows that he doesn't have the authority, but again, we are going to see how this plays out. But let me just, I'm giving you the information based on the content of the executive order that the president signed. So, as I said, I have it titled here, the gold card is finally here. So, exclusively for rich people. You know, currently we have investors who can invest and get green card, but now this one is not investment. This one is a gift. You have to, as an individual, you have to give a gift of $1 million to the U.S. government, and then you have the opportunity to apply for green card. Okay, based on the executive order, it actually says that the president issued an executive order granting green cards to individuals who donate $1 million to the United States on his or her own behalf, and then $2 million gift by a corporation donating on behalf of an individual. So if I'm working for the law office of Olu Asekun, for example, which is a registered corporation, so if I don't personally have $1 million to donate, if the company can donate $2 million on my behalf, then I can still use that to apply for green card according to the executive order. Now, in addition, the executive order mandates the Secretary of Commerce, Secretary of State, and Secretary of Homeland Security within 90 days from September 19. When was September 19? That was Friday, I think, last Friday.
Yes.
Aha. So this executive order was effective last Friday. I think it was signed last Friday by the president. So within 90 days of last Friday, September 19, those three secretaries, that is Secretary of State, Secretary of Homeland Security, and Secretary of Commerce, the three of them, they must determine how much will be the administrative fees to be paid. 2, they must establish a process for application and expedited adjudication of gold card. Like I told you, the donation is just going to give them an opportunity to apply. So they still have to apply. So they must establish a process for application. They must determine when to start submitting the gift for consideration, and they must determine when to start submitting application. They must determine and establish maintenance and transfer fees for corporations sponsoring individuals. Now, what this simply means is that the president signed this executive order on Friday, September 19. So he's saying that from September 19, 90 days from that day, the Secretary of Homeland Security, Secretary of State, and Secretary of Commerce, they must come up with how much to be paid for application. They must come up with the application process. They must come up with where this gift will be, maybe create a special account. I don't know. They must come up with how this gift will be received by the United States, and then they come up with how much the filing fee and all of that will be. Now, here is why I believe that the president actually knows exactly what he's doing, and probably he got a lot of legal advice from people. But the president, we all know that our president is kind of a stubborn person, so he probably still wants to go ahead with this gold card. This is where I'm saying why I'm saying this. The president is probably aware of the limitation of this authority. So there is a caveat in the executive order. Those caveat is what I want to read now. According to the executive order, the president stated that if any provision of this order or the application of any provision to any person is held to be invalid, the remaining provisions and applications shall not be affected thereby. So the president is probably anticipating a situation where some people are going to challenge his authority about this, and then the president is already saying, oh, okay, if let's say the Supreme Court say, oh, Mr. President, you don't have the authority to grant green card, that belongs to so he's saying that the other part, which means, I mean, for people who are smart, what that simply means is that if you already gave them your $1 million, if the court says, Mr. President, you don't have the authority, it simply means you lost your 1 million because it's a gift. So it means that you are not going to get your $1 million gift back, or 2 million if it is coming from a corporation. The second caveat in the executive order, it says that nothing in this order shall be construed to impair or otherwise affect the authority granted by law to an executive department or agency or the head, the function of the director of the Office of Management and Budget relating to budgetary, administrative, or legislative proposal. This order shall be implemented consistent with applicable law and subject to the availability of appropriateness. You see, these are legal languages. The president is giving something on one hand and is giving condition on the other hand that, you know what, I want to give you this, but if you end up not getting it, don't blame me for it. The law is still to be implemented. Whatever I'm signing here is not superior to existing law. Remember, existing law, even the Constitution says that only the Congress can make laws for the United States. Granting a green card is something that is, in my opinion, exclusively the duty of the Congress. I believe, and anybody who has a contrary opinion can challenge me in court or even call me to a debate, the president does not have the authority to grant green card to immigrants. It is the Congress that can establish the law, and then the president will implement that law. So in this case, the Congress has not established any gold green card. They have not passed any law relating to granting green card by people who give gifts. And I believe in order for the president not to be liable for making this assertion, they put all these caveats in there that, well, I'm doing this, but the existing law is still superior. The existing law is still there. If the court finds that this thing is not, I don't have this authority, it doesn't affect whatever you have done, which means it doesn't, the other part of the executive order will be valid, which means that if you have given your money is gone.
Okay, now let me ask you a question. You know how for investors, they want to know where the money came from?
Yes.
They're going to apply the same.
Well, that is not included in this executive order. Let me repeat your question so that my viewers can understand what you are. So what you are asking is that for investors, they have to show the source of their funds. They have to show explanation of where they got the money from and all of that. So your question is whether these donors will have to show the same thing. Again, we don't know that yet, but I'm suspecting, because the president gave the Secretary of State, Secretary of Commerce, and Secretary of Homeland Security the responsibility to come up with how this will work within 90 days. So let's wait and see what they come up with. Maybe in their own requirement, maybe they will say that, well, if you are giving us a gift of 1 million, you still have to explain to us where you got the money.
Yeah, because
Maybe.
all these.
Yeah.
I'm talking about, let's say, drug lords.
I understand exactly what you mean, because if they don't put those conditions, of course, those people who get money through drugs, they can just donate money to the US and then get green card. Again, this is one of the reasons why this executive order, in my opinion, cannot stand the test of, it cannot stand legal challenge in court. And I want to believe that the president knows that. That is why that caveat is put in there, that if the court found that this thing is not, any portion of this executive order is not legal, then the remaining portions will still be active. So I don't think any court will say that if you choose to give a gift to the government, that it's illegal. I don't think any court will do that. But what the court will probably do is that the president does not have the authority to grant green card to immigrants. that is the exclusive power of the Congress to pass such a law. And so far, tomorrow the Congress may pass it, but as of today, the Congress has not passed any such law. So I don't see how this will survive a legal challenge in court. But again, I'm just uh, I'm just mentioning what the president signed as executive order on Friday last week. Now, again, still talking about the caveat, which is again why I know that the president knows exactly what he's doing. Another caveat says that this order is not intended to and does not create any right or benefit, substantive or procedural, enforceable at law or in equity by any party against the United States, its departments, agencies, entities, its officers, employees, or agents, or any other person. So what this executive order is saying is that if you don't succeed in getting green card, you cannot sue us. You cannot sue the government. You cannot sue the agency. You cannot sue USCIS. You cannot sue DHS. You cannot sue the Department of State. You cannot sue nobody. So you just lost your money if you don't get it. Again, like I said, who does that? It is because the president is probably aware of the limit of his power. That's why he's putting things like this in the executive order. So I'm going to wait. I'm not going to preempt what the Secretary of Homeland Security, Secretary of State, and I'm not going to preempt what they will do. But based on the language of this executive order, it will only be a stupid person who will donate this money. Because they are clearly telling you that, okay, if you give us this money and you don't get green card, you know what? You can't sue me, you can't blame me, you can't sue USCIS, you can't sue anybody. You just lost your money. It's as simple as that. So I don't know whether anybody will still donate it. But again, that is the introduction of the gold card. So the gold card is finally here, but we still have 90 days to see what will be the requirement, what will be the application process. Maybe a new form will be formulated. Maybe what will be the filing fee, what will be the requirement. Even though you donate the $1 million or $2 million in the case of a corporation, do you need to explain the source of the money, or you just come give us the money and then you get green card? Even they still have to determine how much allocation, because this is going to come under EB, it's going to come under employment base. So they still have to determine, again, this is one of the reasons why I believe that the president does not have the authority to do this. They still have to determine visa availability. They have to determine visa allocation. So is the president going to say, okay, I'm going to give 1,000 green card in this category? Can the president do that? No, he doesn't have the power. It's the Congress. The Congress will have to go back to visa bulletin. They will have to, currently, there's only 140,000 allocation for the entire EB category. That includes EB1, EB2, EB3, EB4, EB5. So how are they going to take part of those ones? Are they going to take it away and create this gold card, or are they going to create a new one? Again, the president cannot create visa bulletin by executive order, in my opinion. So, to be honest with you, where I come from in Nigeria, there is something called 419. I'm not going to say more than that. For those, if you know, you know.
I want to understand.
If you know, you know. I'm not going to say more than that. So let's go on.
You said 419?
419, yeah. Those, if you know, you know. That's it. That's all I will say.
Okay.
Now, the next update that I want to talk about is another proclamation. This one is not an executive order. It's a proclamation by the president. The president signed a proclamation restricting the entry of anyone seeking to enter or re-enter the United States on H1B status. I know that this one has been in the news.
I know what it means.
Okay, you found out what 419 is. Okay, If you know, you know. So now, I was talking about the president signing a proclamation restricting the entry into the United States of anyone on H1B status and approval of new H1B visas unless the employer pay a $1,000 fee. Now, this is a proclamation. It's not an executive order. It's a proclamation. Okay, unlike the gold card, this one is actually within the authority of the president, in my opinion. It is actually within the authority of the president, and based on the explanation provided in the proclamation, personally, I actually support it, even though it is going to be painful to some people, because when I read the proclamation, the president talks about some very powerful companies that hires as many as 5,000 H1B workers while simultaneously sacking permanent employers, maybe sacking about 10,000 permanent employers. I mean, you can't do that. You can't do that. Even though we know that sometimes the president exaggerates. I don't know if this figure quoted, they are actually true or not. But to be honest, this is one decision that I support from the president, because you cannot do that. H1B is not meant to replace American workers. It is supposed to supplement American workers. Where there are no Americans, that is when you bring in H1B. Yes, H1B has its advantages. Yes, H1B has a lot of benefit, but you can't do it at the detriment of Americans. If Americans are jobless, why will foreigners be getting jobs? I mean, it doesn't make sense. Personally, I support the president on this, assuming that the figure quoted by the president is right, because we all know that the president sometimes exaggerates some of these figures. But let me also explain the proclamation, because there are a lot of things. This thing has been going on social media. I mean, a lot of people have been sending questions to me. Oh, is it true? How does it? In fact, somebody sent a video to me of some people who were in Emirates airline, and as soon as that proclamation was signed, they all disembarked, because apparently majority of them were on H1B. They were Indians on H1B. Maybe they were going on vacation. They became so scared, they decided not to travel on that Friday that this proclamation. Somebody sent that video to me. So a lot of things. That is why I want to talk about it, and I want to clarify it, because it actually does not affect those people. It does not affect those people. So that is why I want to explain it and clarify it. So starting from, okay, let me say this. The proclamation does not affect the following categories of people. Number one, if you are the beneficiary of a petition that was filed before the effective date. When is the effective date? September 21st. When was September 21st? That was Saturday, or that Sunday? 19 was Friday, 20th will be Saturday, 21st was Sunday. Yeah, last Sunday. So effective date was last Sunday. So yeah, 12 a.m. on 21st. That was the effective date. So if you are the beneficiary of a petition that was previously filed before September 21st, 2025, you are not affected by this 100,000 fee. Number two, if you are the beneficiary of currently approved petitions and you are in the United States, it does not affect it. It does not affect you. Even if you are outside, if the petition has already been approved, you are not affected by this new 100,000 fee. In addition, if you are the beneficiary or you are in possession of a validly issued H1B non-immigrant visa, even if you have not entered the United States, if you already have your valid H1B visa, this $100,000 does not affect you. But if you are still going to apply for a visa, if your employer is still going to file a petition with USCIS H1B petition, then they must pay the 100,000. But if you already have your visa, the 100,000 does not affect you. Another set of people who are not affected, if you are okay, it does not affect the ability of any current visa holder to travel to or from the United States. That is why I said those people who are in the plane, that Emirate plane, they were not affected, because if you already have a valid H1B visa, this proclamation does not affect you. You do not need to worry. You can go in and out of the United States. Now, both USCIS and CBP, they have indicated to us that the proclamation only applies to H1B petition filed after the effective date. And as I said, effective date is September 21st, 2025. Only applications filed after September 21st, 2025, on or after September 21st, 2025, will be affected by the new fee. Now, the Department of State also indicated to us that the proclamation only applied to aliens seeking visa issuance or entry into the United States based on H1B petition that was filed with USCIS after the effective date. After the effective date. So it means that if your application H1B application has been filed, even if you have not applied for visa, for as long as it has been filed before September 21st, you are not affected by this proclamation. The Department of State also indicated that no H1B visas have been revoked based on proclamation. This information was given to us yesterday. Excuse me. So as at yesterday, the Department of State has not revoked any H1B visa because of the proclamation. So anyone who has a current H1B visa, they are not affected by the proclamation. Another thing I want to say about the proclamation is that the proclamation does not change any payment or fees required to be submitted in connection with H1B renewals. So if you already have H1B and you are renewing it, you are not affected. You don't need to worry. You don't have to pay the 100,000. The employer does not need to pay the 100,000. The 100,000 fee is a one-time fee on submission of new H1B, not renewals. New H1B. It is only for submission of a new application. So it does not. Right now, USCIS has already finished with fiscal year 2025. The deadline has already passed, so I don't think any new application will be accepted by USCIS this year. So the new one is probably going to be fiscal year 2027, which they are going to start the selection process from around March of next year. So those are the people that will need to pay the 100,000 fee, new applications. Now, the proclamation, however, it gave exception. There are some exceptions to this proclamation. This exception they are on a case-by-case basis. For someone that the Department of State or the Department of Homeland Security determined that it is in the national interest of the United States that the exemption will not pose a threat to the security or welfare of the United States. So the Department of State and the Department of Homeland Security, they are still going to have some form of discretionary decisions regarding whether somebody should be granted an exception to the payment, or whether a company should be granted an exception to the payment of the 100,000 based on a case-by-case basis. They are the one that will determine whether it is in the interest of the United States to waive the application of the 100,000 fee. However, I want to say that based on this proclamation, there are still a lot of unanswered implementation questions that we continue to seek. In fact, excuse me. In fact, I was going through ALA yesterday, our platform, that is American Immigration Lawyers Association platform, and a lot of questions were posed there that we currently don't have an answer for. Nobody has an answer for it. So I wrote out some of the questions. The first question: whether visas will be issued for renewals, changes of employer, amended petition, cap exemptions, or for H1Bs filed after the effective date without the fee payment. Again, we don't know how the proclamation is going to affect change of employment. So if you are currently on H1B with an employer, that will be considered an existing petition. Now, if you want to change your employer, especially if the employer is a first-time H1B, so now we don't know how USCIS or Department of State is going to treat that. A change of employment, are they going to treat that as a new application, or are they going to treat it as an existing application? We don't know yet. We will continue to ask, but right now we don't know yet. The next question we don't know the answer to: whether extension of stay application, including change of employer or amended petition for those in lawful H1B status, or change of status application filed on or after September 21st, 2025 be adjudicated without the payment. Again, for people who are already in the US and they are applying for a change of status, we don't know how that will affect the employer. We don't know yet. Hopefully, USCIS will clarify it. All these questions that I'm reading out, they are questions that have already been sent to USCIS and DHS. We are just waiting for a response. Once we have a clear answer, I will come back to the podcast to give us the answer from USCIS. But another question we don't have an answer for: whether cap-exempt employers will be subject to the ban and imposition of the fee, giving references to the lottery. Again, currently, there are some cap-exempt organizations. If you are a non-profit organization that is involved with education, they are exempt from the cap. Right now, are they going to be exempt from the payment of the 100,000? We don't know yet. These are questions that have been sent to the DHS, and we are waiting for a response. Another question we don't know the answer to: how payment of the new fee is going to be made. Is it going to be the same process that we use to pay the filing fee right now, or are they going to create a special platform or portal for the payment? Again, we don't know yet. These are new things. We are waiting for response. Another question we don't have an answer to: does the fee apply to H4 dependent? You know that H1B is only for principal applicant. So the dependents are also in H4 category. So are the H4 dependent also going to pay the fee? We don't know yet. My suspicion would be no, but again, I don't want to base I don't want to base what I'm saying on assumption. So we just have to wait for USCIS to clarify and provide all these answers. The last question: what documentation or information will an H1B visa holder need to present to CBP in order to demonstrate the payment? We don't know how USCIS is going to treat this. When payment is made, are they going to issue receipt notice the way they normally do right now? Again, these are questions we don't know right now. I see that we have spent a lot of time on this update. Do you think I should still talk more about the update, or just go into questions and answers? People should continue to send in questions. They should continue to send in questions.
On the
What?
on the live chat.
Yeah, please send in your question on the live chat because it is easier for us to see question on the live chat rather than look for questions on cell phone. Please send it on the live chat. Now, before I go on, there's one more thing I want to say. Let me see. Okay. EOIR, Executive Office for Immigration Review, they just released a new memo regarding immigration judges, immigration court priorities and performance. This is something that will also take time, but I'm just going to make some points regarding these new policies. Under these new policies, immigration judges, they are required to, let me just read it, 95% of non-status detained removal cases should be completed within 60 days. 60 days is only 2 months. That is humanly impossible considering the number of cases that are currently present at immigration courts nationwide. But the Executive Office of Immigration Review is telling immigration judges that they must complete 95% of the cases in front of them for people who are in non-status. They must complete it within 60 days. 95% of all non-status detained removal cases should be completed within 1 year. 95% of all non-status, non-detained. That means if you are in removal proceedings but you are not detained, irrespective of what application you present before the immigration judge, they are telling the immigration judges that they must complete at least 95% of it within 1 year. The next thing, 95% of all motions should be adjudicated within 30 days. Again, there are tons and tons of motions. You can have motion for change of venue. You can have motion for change of attorney. You can have motion to reopen. You can have motion to reconsider. You can have motion to substitute counsel. You can have motion for late filings. You can have so many motions. But the EOIR is telling immigration judges that they must complete 95% of all motions within 30 days. Within 30 days. The next one, 95% of all custody redetermination requests should be completed within 5 days of the request for redetermination. Again, I don't see how these things are possible. They are saying that for everyone who is detained, if we file a motion to motion for bond, immigration judges must complete at least 95% of motions within 5 days. Again, I don't see how these are possible. The next one, 95% of all merit hearings should be completed on the initial scheduled individual merit hearings. Again, 95% of all merit hearings. Merit hearings means individual hearing. So if you are scheduled for individual hearing, based on this new policy, a lot of immigration judges are going to be denying a motion to reschedule, motion for continuance. What happens where you have a pending application that has not been adjudicated by USCIS, especially I-130? Look at the National Benefit Center. Current processing time for I-130 is now about 52 months. 52 months. That is almost 5 years. And yet, the EOIR is telling immigration judges to complete these cases within 1 year. How is that possible? That is humanly impossible. If they want this thing to be expedited, they have to start with USCIS. If USCIS is not adjudicating petitions, if USCIS is not timely adjudicating cases, how is the immigration judge going to finish this thing within the time required? It's not possible. So this is just an indirect way of telling of telling immigration judges that whether petitions are adjudicated or not, once somebody is placed in removal proceedings, you must deport them. That is the direct meaning of all these policies. The next one here, it says 100% of all credible fair review should be completed within 7 days. Oh my God. 100% of all credible fair review should be completed within 7 days. For those who don't understand what credible fair review means, is that if somebody is detained and this person wants to apply for asylum, you are required to face an asylum officer who will conduct a credible fair interview to determine whether there is a chance, whether there is a prima facie evidence for you to apply for asylum. So what this simply means is that a lot of people will just be returned from the border. A lot of people will just be returned from the port of entry, because the current number of asylum officers cannot handle this request. We have clients in our office here who apply for asylum as far back as 2018. That is how many years now? That is 7 years plus. And they have not even been scheduled for interview. It is these same asylum officers who are going to conduct credible fair interview. How is that possible? How is that possible? It's not. Anyway, the next one, 95% of all institutional hearing program removal cases should be completed prior to the alien's release from detention by the institution hearing program custodian. The final one, 100% of all electronic and paper record should be accurate and complete. Honestly, the only thing I can say is that I pity immigration judges right now. I pity them, because I don't even know all these responsibilities given to them. I don't see how they are going to comply. I don't see how they are going to be able to do all these things. Meanwhile, they are the one that the aliens will be facing. They are the one that the immigration lawyers will be facing. They are the one that everybody is going to be blaming for all these things. But the authority controlling them is giving them tasks that is not possible for them to complete. But we will see. I see that our time is fast spent. Let's go to questions right quick. Okay. The first question. Good day, our seasoned attorney. May the God of all sufficiency continue to exceed your expectation. Amen. Pleasantly, and bless your team members as well. Thank you for the free knowledge and insight. Thank you. We appreciate it. Can you please move on? Move forward. It's not a question. It's just a compliment. Okay. Another day to learn from the master. Oh, thank you. Okay.
That's the question.
Okay, that's the question. Okay. Please, how long should one wait to file for permanent residency after marriage? My citizen spouse got divorced in June 2nd, and we got married September 22nd. Thanks for your expertise advice. Okay, good question. There is really no time limit to file. There is really no time limit. However, in view of the recent adjudication procedure, I will advise that you put your house in order before you file. When I say that there is no time limit, you can get married today and file today. There is no limit. And I can tell you for certain, in our office here, we have represented a client, at least few clients, who got married same day and we filed the petition same day, and it was still approved. There is no requirement that you must wait 1 month, 2 months, 10 months, 1 year, 2 years. No, there is no such requirement. You can file at any time. However, having said that, in view of the fact that this administration is going through what is called extended review, so before you file, I will advise you to put your house in order. Number one, after your marriage, did you start living together before or after marriage? If yes, ensure that both of your names are already in your list. Have you started commingling your assets? Have you started doing things together? Do you have joint bank account? Do you have joint utility bills, insurance, health care, auto insurance, things that a normal husband and wife will do together? So, because under this current administration, it is better, not that it is mandatory, but it is better to have a few evidence of your relationship that you will be able to attach with your petition before you submit it. So the first thing you need to do, if you have not started living together, don't file until you start living together. So once you start living together, ensure that both of your names are already contained in your list. So if you have a prior address, change your address to the new address where you are living. If who is moving in with each other, if you are the one moving in with your husband, ensure that your name is added to your husband's list. If your husband is the one moving in with you, ensure that your husband's name is added to your list. So put all these things together before you file. That would be my advice based on the current situation. But is there any specific number of waiting period? No, there is no such thing. Next question, please. Dear sir, thanks for all you do. I just noticed that USCIS has kicked off scoops which impact EB4 and EB5. This development actually reduces processing time positively. What should the applicant expect based on this new development? Well, the good thing is that we are starting fiscal year 2026 next week. Is it next week? Yeah, October 1st. So I believe that by next month, probably a lot of these things will move. So I am optimistic the way you are. So let's just see how it works. So I believe that a lot of these things should move by next month once we see the visa bulletin for next month. So I believe that things should move. I'm optimistic as much as you are. The next question. Sir, given the current debate in the US Congress, what are the most realistic immigration reforms we should expect in the next 12 to 18 months, and how will they impact families already in the US? Well, what I want to say, okay, is there a continuation? Okay. Oh, okay. I think, let me answer it one by one because I think they are separate questions. What I want to say is that I actually don't like the idea of speculating because, you see, where there is expectation, there is always be disappointment. In the last, I will tell you this, since 2004, my expectation as regards immigration solution in the Congress, they have been fluctuating. It will rise and then fall. It will rise and then fall. I remember when President George Bush was the president, he presented immigration bill to the Congress, which was controlled by the Republican at the time. President Bush was a Republican president, and they presented it. He passed through the House of Representatives, but guess what? The Senate killed it. The Senate was controlled by the president. The Senate was controlled by the Senate was controlled by the Republicans. The presidency was controlled by the Republicans. And guess what? The Republican Senate killed it. So I didn't have, the expectation was dashed. Of course, at that time, their reasoning was the effect of 9/11, which was still ongoing as at that time. So that was it was understandable at the time. Again, when President Obama won the presidency in 2008, I remember that one of his cardinal point for seeking election was that he was going to fix the broken immigration system. When Obama became president, the Democrat they had what is called super majority in the House. Super majority. That means that the Democrat had more than 60 senators out of 100, which means that even anything that requires the passage of two-thirds majority, they could have done it. We had very high hope. Did they do it? No, they didn't. In 2015, 2016, when President Trump won the presidency, he promised that yes, he was going to fix immigration. And I sincerely believe that he wanted to. But of course, he faced opposition from the Republicans. So many proposals came up. In fact, he wanted to really help the DACA recipient. But guess what? Court cases here and there, opposition from the Republicans. At the end of the day, nothing happened. The hope was raised, it was dashed. When Biden became president, when he won the presidency in 2020 and he was sworn in January 2021, the very first bill that President Biden sent to the Congress was immigration bill. Again, at that time, the Democrats were controlling the Congress, they were controlling the House of Rep, and they were controlling the Senate and the presidency. Did they pass it? No, they didn't. Again, they blame COVID for that. They needed to tackle COVID first. At the end of the day, they didn't do it. So, here we are again. If you look at the history, I'm not going to raise my hope, but I believe that if the current president wants to do it, is in a position to do it. If the current Congress wants to do it, they are in a position to do it. So we wait and see what they will do. Next question, please. Thank you again, Dr. Asekun, for this weekly knowledge sharing session. God will continue to bless you, sir. My question is, with the newly announced 100,000 fee for new H1B petitions effective September 2025 and its uncertainty around whether it applies to change of employer or extension cases, how should employers and visa candidates strategically plan now to avoid being caught off guard? Well, they are already caught off guard because it is effective immediately. It's already effective. So if it is something that is going to be effective in the future, that's when we can start talking of making plans, strategizing. But everybody is already caught off guard. The thing has already been announced and is already effective as of September 21st. So it's already effective. So there's no room for strategy right now. I just pray that those who will be affected negatively will have other options. But to be honest with you, if the president's statistic that was quoted, if it is true, I honestly think that the president did the right thing, because you can't be sacking Americans while you are bringing in foreigners. That will be counterproductive. Okay, the next question. If someone gives birth after DQ, document qualification for consular follow to join, EB follow to join, does the child take the DQ date of the mother or the whole process start all over again? No, if the document has already been documentarily qualified, if you have a child, send the birth certificate of that child to the National Visa Center and update them. If your file has been forwarded to the embassy, the NVC will send you a response notifying you that your file is already at the embassy and that you should contact the embassy. So at that stage, you should also send the birth certificate to the embassy and they will update your information. They will ask you to pay immigrant visa fee for the new child, assuming that the petitioner, anyway, since it's a follow to join, so I assume that the petitioner is not a citizen. But yes, that is the way to handle it. Send the birth certificate to the NVC and ask them to update your information as your family has now been, you now have an addition to your family. Next question, please.
Filling of DS to 60.
No, they are not. They don't need to do all that. So, like I said, they just need to. I already answered the question. They don't need to notify the NVC with the birth certificate of the child. So the NVC will issue a new invoice for that child, and of course, a child that is just born will not require to go through biometrics or anything like that. So that will not be necessary. You are not going to start all over again. You just continue where you stopped. Okay, the next question. Okay, question 1 of 3. Good day, sir. God bless you and your team. Amen. For green card, I'm submitting a birth attestation from NPC, Nigeria. Do I also need to add my baptismal certificate as secondary evidence? My concern is that the baptismal certificate has my passport first name, but also other names not on any official document. Kindly advise.
That's question 3.
Okay. Also, that's a separate question. Let me answer the first one first. If you already have attestation of birth from National Population Commission, I will suggest that you limit your submission to that, because that is accepted by either the Department of State or USCIS in connection with green card application, especially because your baptismal certificate have other names that you don't have on your other document. That can complicate things, because now, depending on where your case is, either USCIS or Department of State, they can ask you to start proving that those names and the name that you have, they are one and the same person. So you don't create a problem where none currently exists. So just limit it to the attestation of birth from the National Population Commission, and don't complicate things with the baptismal certificate. The next question: when filing I-485, should I follow the final action date or the date for filing? My priority date is January 12, 2024, EB2 NIW. Again, this person didn't indicate where he or she is. The difference between between visa application and final action is that final action is for people who are physically present in the United States. So if you are here in the United States and you are applying for adjustment of status, you should follow final action. Visa application is for those who are physically outside of the United States, who will go through the embassy. Those are the ones that uses visa application. So if you are outside the United States, you have to use visa application. But if you are inside the US, you have to use final action date. Next question. Hello, sir. I have I-360 pending since 2024 with 2 prima facie received and 5 years EAD. Can I travel within the US, another state? Oh yes, if you have a valid form of ID. Remember that I can't remember the effective date, but I know that the real ID is already effective. So if you have an ID, if you have 5 years employment authorization, you should be able to obtain either a valid driver license or a state ID. Yes, with a valid state ID, you can travel within the United States. And in addition, just make sure you keep your EAD with you. But yes, you can travel within the United States with a valid ID. If you don't already have a driver license or state ID, go and get one, because real ID is already effective. The next question. Hello, doctor. Thank you so much for all what you are doing. You're welcome. Thank you. Please, sir, you have not replied my email. I sent gentle reminder, but I haven't heard from you till now. I don't know who this is. Can you please? Well, if this person is listening, can you?
Send another email. Follow up email.
Okay, can you send a follow-up email? Then I don't know what email address they sent it to. I hope it's not oluasekun.lawyer, because we've been having challenges accessing that email lately. So send your email to info@olufiade.com. Is there a way you can identify who this is, and contact the person and see what the email is all about? Let me also say this. I received tons of messages, tons of emails. We received email from USCIS, we received the email from Department of State, we received email from even embassies, we received email from clients, we received email from the court. I mean, we received tons and tons and tons of emails. And that is why I encourage people, if you have questions relating to this podcast, if you have questions during this podcast, the chances of answering your question will be much higher if you post your question live. I try as much as possible, except when I'm rushing to court, to answer at least majority of the questions. So try to send in your question live instead of sending it through email, because sometimes I miss some of this email. I'm a human being. I mean, sometimes I just open my email and you see like 2,000 messages. So it's not as if I'm going to sit in front of computer 24/7 checking all of these things. And sometimes we also receive a lot of junk emails, advertisement, a lot. So you have to seek through all these things to select these ones that are relevant, the ones that are irrelevant. It's a lot of work, but I will try my best. But if you have questions, your best way is to send it live through this podcast. You stand a better chance of getting your questions answered, especially when I'm not rushing you to court. I take my time to answer it. Next question. Good day, doctor. Thanks so much for what you do for us. Okay. God bless you. Amen. I'm a Nigerian. My USA citizen son filed for me as a father since September 2022. My documents were approved in August 2024. And since then, I have not been called for interview. I am still in Nigeria. Please, what I want to know, when I will be invited for interview. Well, this person didn't indicate whether he has finished the NVC processing. He just said my document was approved. So I'm assuming, I will answer the question both ways. So if I'm assuming that the I-130 was approved, but if the only thing that was approved is the I-130, then you still need to go through the NVC process. However, if the case has been documentarily completed since September 2022, then no. It says approved in August 2024. Okay. So if the case has been documentarily completed since August 2024, because as a parent of a US citizen, you fall within the category of immediate family, which will require attention. So if the case has been documentarily qualified since August of 2024, then my advice would be for you to tell your son, who is a US citizen, to seek congressional intervention. I tell people that the best time to enjoy congressional intervention is now, because this is the election. This is the time that electioneering campaign is going to start. I mean, all the congressmen now, they are going to pay attention to their constituents. So they are going to want to be the nice guy, the nice person. This is the right time. So tell your U.S. citizen son to seek congressional intervention. Next question, please. Yeah, I think that is the response to the answer I gave before. The sign, or what do you call that?
No, he said that one before you responded.
Okay.
Yes.
Next question. Sir, what chance does an R1 visa holder have who has marked up the eligibility period of 5 years but is waiting for a priority date after the I-485 was administratively closed due to the priority date? Well, If your 5 years is already out, you may have run out of option. But if your 5 years is about to run out, you can still change your status. On the other hand, if your I-485 was filed before the expiration of your 5th year, and thereafter your I-485 was administratively closed, I will still advise you to go ahead and apply for a change of status. Maybe you can apply for a change of status to F1, but if you are going to go to school, make sure that it's a religious school so that it will still be in connection with your religious petition. However, if you are going to do this, you have to include an explanation as to why you are filing a change of status application out of time. I believe we did this successfully for someone recently. Somebody whose 50 years has already expired as at the time we filed it, but because the application was initially accepted, so we believe that it was going to be okay. But when it was eventually administratively closed, so we used that as the basis for late filing. So that is what I believe that you can do. And if you are going to do that, I believe that time will be of essence. So you have to do it within a very reasonable time of the I-485 being administratively closed.
He sent another question, this person.
Okay.
It's here.
Okay. If you want to switch to F1, since my priority date is still in November 2024, to keep me in status pending I-485 priority availability, what is the chance of getting F1 approved since it's not a dual intent? Yeah, it's not a dual intent application. Yes, like I said, it's a discretionary thing. That is why you need to provide an explanation. You don't just file and apply for a change of status. No, you have to show that this is the reason why you are doing it. Of course, when you submitted the I-360, you already indicated that you are intending to stay here, which again is inconsistent with a change of status to F1. But all these things are still looked at on a case-by-case basis. That is why you need to provide a detailed explanation as to why you are doing this. So the next question. Good afternoon, sir. Thank you for all you do for humanity. You're welcome. Thank you. I'm on removal proceedings and apply for asylum. My EAD card is out and I've been scheduled for master hearing for next year, January. Is it advisable to move to another state since I got admission for school in another state? Well, there are a lot that I don't know about this case, so to give an answer will be really difficult. Number one, if you already apply for asylum, the probability of getting student status approved is going to be very, very minimal. It's going to be very low. Number two, if your I-94 has already expired, even before you apply for asylum, that makes it even more difficult to approve. Number three, even if you apply for asylum before the expiration of your I-94, because F1 is not an immigrant, it's not an application for permanent residence, it may be difficult to approve. In my opinion, to get you changed from your asylum to F1 will be almost impossible. I'm not using the word impossible. I said almost, but it will be very tough. Because, you see, when we talk about ability of people who file asylum before the expiration of their I-94, their ability to adjust status, that is in connection with the requirement of adjustment of status. The requirement of adjustment of status is completely different from the requirement of someone who wants to change from asylum status to F1, which is a non-immigrant visa. So that may be tough. But more importantly, if you are already out of status, it will be a very difficult one. Next question. My document were...
Sorry. You already answered that one. I'm sorry. Yes, you already did. This one.
Okay, good afternoon. What about people who want to transfer H1B to another employer? Is there any clarification on that? No, not yet. I believe that is part of the ones that I explained that we are still waiting for clarifications. Yeah, whether the...
Francis mentioned it in his message.
Yeah, what document... Yeah, what extension of stay application, including change of employer or amended petition? Yeah, that is one of those ones that we are still waiting for clarification. There is no clarification yet. So once we have a clarification, you can be sure that I will come back here to talk about it. The next question. Good day, sir. Is it advisable to attend a marriage-based interview without legal counsel? And are there any risk of detention? Good question. I've stated it on our podcast several times. If you have a pending application and you are going for interview at USCIS office, the first thing you should do, whether you have a lawyer or not, go to EOIRK status portal. EOIRK status portal. You can go to Google and just type EOIRK status portal. Just type it on Google. It will lead you to the portal. Click on it. It will ask for your alien number. You put in your alien number. It will ask you for your country of citizenship. You put in your country of citizenship, and then it will tell you if you are in removal proceedings or not. Because if you have a removal order and you go to immigration office, the probability that you are going to be arrested is 100%. The probability that you are going to be arrested is 100%. So, whether you have a lawyer or not, if you have any application, it doesn't matter whether it is marriage-based, whether it's employment-based, whether it's a self-petition, whatever it is, if you are required to attend an interview, the first thing, go on Google, search EOIR case portal, case status portal. Once you log in there, it will ask you for your alien number. It doesn't require registration. It doesn't require anything. Just go on Google, type in EOIR case status portal. It will go into it, click on it. It will ask, it's a US government website. It will ask you to agree that you are logging into the US government. Just click OK. Then it will ask for your alien number. Put in your alien number. It will ask you for your country of citizenship. Select your country of citizenship and click search. It will tell you if you have a removal order or not. If you have a removal order, even if you go with a lawyer, they will still arrest you, and there's nothing the lawyer is going to be able to do. So that is the first thing. Now, once you clarify that you are not in removal order, then the next question becomes, based on recent development, remember, the administration have stated that they are creating a special agency. Personally, I've not seen it in operation yet, but that doesn't mean they will not start today. So because they have already indicated that creating a special agency, that they will have the authority to carry gun, they will have the authority to shoot at sight, they will have the authority to make arrest, they will even have the authority to arrest lawyers if they find out that the case is fraud. Because of all those circumstances, will it be advisable to have a lawyer? I will say yes. It is advisable to have a lawyer for several reasons. Number one, if you are separated during the interview, each of you is not going to know what happened to the other. But with the presence of a lawyer, the lawyer will always know what happened at the interview, because even if you are separated, When they are talking to your wife, the lawyer will be present. When they are talking to you as the petitioner, the lawyer will be present. If, on the other hand, you are the beneficiary, the lawyer will be present. If your wife is the petitioner, when they are talking to your wife, the lawyer will be present. So the lawyer will be able to understand what is going on. The lawyer will be able to know what happened during the interview. And in some cases, the lawyer may even intervene if the case is not going well. I mean, I have done that several times on behalf of clients. If I realize that the interview is not going as expected, I stop the interview. Why is that beneficial? That is beneficial because the more you continue, the more you provide information that they are going to use against you. Remember, this is a country where we have what is called the Fourth Amendment right, the right to remain silent, the right to prevent self-incrimination. So if the lawyer is there and realize that things are not going well, the lawyer can stop the interview. The lawyer can intervene. So is it beneficial to have a lawyer? Yes. Is it mandatory? No. It's your option. If I'm in your position, will I use a lawyer? Probably yes. Next question, please. Hi, sir. My I-140 priority date is current, but I have a pending asylum case with New York immigration judge. I applied for asylum before my visa expired. What steps can I take regarding adjustment of status? Number one, I have to be sure that this person understands the difference between visa and I-94. So this question, I'm not going to be able to answer it without clarity because I-94 and visa, they are not the same thing. You may have a valid visa and you may have been out of status. What determines whether you are maintaining status or you are out of status is not your visa. It is the I-94. So I need to know, is your I-94 still current? If you apply for asylum before the expiration of your I-94, not the expiration of your visa, you may still be able to apply for adjustment of status. But if your I-94 is already expired, even if your visa is current, you will not be able to apply for adjustment of status. Next question, please. Sir, if we decide to self-deport, myself and hubby, or if we call ICE for deportation, can it affect the children? Because I want the children to stay back. Well, I don't know if you have any pending application either for yourself or your spouse or for the children, or they have their own independent. You see, I don't even know the status of this person. I don't know if you are currently in removal proceedings or you don't even have anything at all. Because there are so many things. If your children are currently not in removal proceedings, your self removal or self-deport is not going to affect your children because they will have to deal with their own self. But if you are already in removal proceedings, for example, let's say you already filed an asylum and in your asylum application, your children are included, and then maybe they give you a referral notice, you are already in the removal proceedings and your children are already a rider in your application. If you depart, it will affect the children because whether you are there or not, once the immigration judge calls their case, they will still have to go to court and defend themselves. But if you are not in removal proceedings, if you have not filed anything that involves the children, yes, your departure will not affect them. They will have to deal with their own case. Next question, please.
Okay, so this person right here, Angel, they just replied saying that he applied for it prior to the expiration of the I-94.
Yeah, if he applied for it prior to the expiration of the I-94, then he may still be able to apply for adjustment of status. Since he's already in removal proceedings, USCIS will not have jurisdiction over the case. So the adjustment application will have to be filed at the immigration court. And of course, if you have a lawyer, tell your lawyer to file adjustment application for you at the immigration court. Yes, you may be able to apply If you want to understand the basis of your eligibility, you can go back and look at our podcast that talk about unlawful presence versus unlawful status. Unlawful presence versus unlawful status. You can go back and look at it. And if you have a lawyer, if your lawyer is telling you that you may not be eligible, tell your lawyer to also watch that podcast. The title is Unlawful Presence versus Unlawful Status. Okay. If you don't know how to get the podcast, go on Google and type Dr. Olu Asekun on unlawful presence versus unlawful status. It will get you directly to the particular podcast.
Okay, so now this question, Oyin.
Yes.
She said no removal proceeding, but have the Vawa application still pending with the kids, but I don't know what the husband has pending. The one that wants to know if the kids will be affected if they self-deport.
Well, if Vawa application is pending, she is probably the applicant. So if the Vawa is approved after they depart, the children may still be able to apply for adjustment of status. On the other hand, if there is an RFE, if there is a request for evidence or a notice of intent to deny, then responding to it from outside the United States, depending on what was requested, may be challenging. But if it is something that can be provided, yes, will the children be impacted? No, they will still be able to follow through if the VAWA is approved. But of course, if the VAWA is not approved, then they will have to find a way to regularize their own status. But will your departure affect them? No, for as long as you are not in removal proceedings. Next question. Good day, sir. Is it advisable for someone out of status to apply for asylum? Well, out of status, is it out of status but within 1 year or outside the 1 year? Because there are two different situations. If you are out of status because your I-94 has expired, but you are still within 1 year, if you are eligible for asylum, you can still apply for asylum. However, if you have been here for more than 1 year, do not apply for asylum because you will be denied. There is a statutory requirement that you must apply for asylum within 1 year of entry. It is a statutory requirement. It is difficult to be waived, except in cases where there is a war in your country or some major thing that can justify exceptional circumstances why you are applying outside of the 1 year deadline. But it's a very, very difficult hurdle to cross. So if you have already been here for more than 1 year, then you don't apply. However, even if you have been here for more than 1 year, if that is your only option, for example, if you are picked up by immigration and you have a good eligibility requirement for asylum, you still have to go ahead and apply, because even if you are not eligible for asylum, you may still be eligible for withholding of removal. The requirement for withholding of removal is a little higher than the requirement for asylum, but withholding of removal does not have the 1 year deadline requirement. You only need to prove that you have been harmed in your home country by the government or from someone that the government is unwilling or unable to control. But the 1 year deadline is not part of it. So if you are already in removal proceedings, if that is your only option, yes, do it. Because someone who is on the floor need not be afraid of falling. It is only somebody who is standing that will be concerned about falling down. So if you are in removal proceedings and you are considering defensive asylum, yes, you can still do it, because even if you are not eligible for asylum, you may still be eligible for withholding of removal. Next question. Good day, sir. If I have a pending I-360, can I close it and apply for marriage-based green card application? Yes, if you have a pending I-360 based on Vawa, if you get married, that Vawa application is no longer approvable. Marriage is a bar to a Vawa petition. So once you get married, the Vawa cannot be approved. So even if you don't withdraw it, they will still deny it, because the moment you get married, you are no longer eligible for Vawa. So if you have remarried, yes, you can submit your application. I will advise you, before you attempt to withdraw your Vawa, after your marriage, submit your application first and get a receipt notice before you now decide to withdraw your Vawa. But yes, once you get married, the Vawa is not approvable, so you can go ahead and withdraw it. So next question. God bless you, sir. Amen. Got 3 years extension on my green card this year, May. Can I travel to Nigeria, and for how long? 3 years extension on green card. So I'm assuming that that must be a conditional green card.
Yes.
So that cannot be a 10-year green card. Yes, if this is a conditional green card.
It says extension, not a card, but a letter. Will Nigerian immigration accept it as green card?
Yes, the only thing you need to show the expired green card, the original extension letter, and your passport. Yes, they will accept it. It's a valid means of traveling. They will accept it. But as I always tell people, if you have a removal of condition, if you have a conditional green card, always make sure that you are in good situation, you are in good stand with your spouse before you travel, because on your return, if you are not in a good book of each other, if they call your spouse and your spouse says something negative, you may run into some challenges. But if you are good with your spouse, yes, you can use the extension to travel. There's no problem. It is recognized, definitely. Okay, this person was clarifying what 419 means. Well, if you know, you know, as I said. I'm not going to say anything more than that. The next question. Greetings. I want to thank you and your team for the great work you are doing. Thank you. You're welcome. I watched your podcast last week where you mentioned that the October visa bulletin shows EB4 is not current. Is that a continuation?
Yes.
Based on your video, are you making this projection from insider knowledge on how visas are allocated, or strictly from the bulletin? My priority date is February 4, 2019. Does this mean I cannot move? Where is
That's the
it?
only thing he sent. Nothing else. Move. Maybe as in.
Well, I remember when we talk about the visa bulletin, we were actually looking at the current visa bulletin. I didn't say it.
Last week, right?
Yeah, I didn't say it offhand. We were looking at the. Can you check now? Let's just.
He just wants to know if it's something that you know that, like, unofficially.
No.
Released,
It,
or you just base it on what is
it was based on the visa bulletin that was released.
Workers too.
Huh?
And we were talking about religious workers and how that one says you. And
Yeah, you simply means unavailable.
I know.
Yeah, so and that it was based entirely on what was released. But I'm hopeful that once they release the one for next month, there will be some movement because of the new fiscal year.
That's what we're thinking last year.
Well, like I said, that is my hope.
Yeah.
I didn't say I'm certain. I said
No.
I'm hopeful.
We don't
So-
just hope here.
Yes. Yeah, that is my hope. Yes, the next question. As a parent of an 18-year-old serving Army Reserve, can she file for her parents? Unfortunately, no. She will have to be 21 before she can file a petition. Only for the purpose of immigration benefit, U.S. citizens who are 21 years and older are considered adult for the purpose of petitioning for parents. An 18-year-old can petition for a spouse, but they cannot petition for parents.
I don't get it. So the person is mature
That's
enough
that's the law.
to get married, but not to petition for the parents.
Yeah, let me tell you the why it is reasonable to some extent.
Okay.
If you look at a U.S. citizen petitioning for children, the immediate family members are considered children under 21. So if you are in that category, you are still not regarded as an adult. So the law cannot treat you as a child on one hand and simultaneously treat you as an adult. That would be inconsistent.
I hadn't seen it like that. Yes,
So
now that, yes.
yeah, that would be inconsistent. So it's either you are an adult or a child. You can't be both. You
But
can't
now
be
in a
both.
different category, you're now considered adult enough to apply for a spouse.
Yes, because even a parent, a U.S. citizen parent, cannot petition for you if you are under 21 and you are married.
Yes.
So
that's right.
it's still the same thing. So that adulthood is still there in both cases. Even if you are under 21, the moment you get married, you are considered an adult. So you can petition for your spouse, and in the case of your parents, they can no longer petition for you as an unmarried child under 21.
Married.
They cannot petition as an unmarried child. So the only option would be to now petition for you as married child. So it makes sense. The next question.
That's it. I mean, we have more questions, but that was the cutoff time.
Okay. This is not a question. You say questions sent after this time will not be answered.
That's our message telling people
Cut
that.
off the question.
Okay, there
I
are
mean, there are more questions, but that's what we.
so how many more do you have there?
Many more. More than 20.
Let me answer a few more because, like I said, today is just one of those days that we have time. I'm not rushing to court. Sometimes I'm rushing to court. I don't even have 1 hour. Maybe I answer about 5 more and then we stop. Okay. Will it be? Is it tagged? What does that mean? Okay. Will it be advised? Will it be okay? Will it be tagged inadmissible for EB1 to file for one that traveled to Mexico 5 days before his 6 months expired and detained by CBP at the border with strong advice to leave in 5 days? He filed in 2 days after. There are so many abbreviations. I'm struggling to understand this thing.
Yeah.
Will it be tagged inadmissible for EB1 to file for one that traveled to Mexico 5 days before his 6 months, 5 days before his 6 months expired, and detained by CBP at the border with strong advice to leave in 5 days? He filed 2 days after the detain.
He came back into the United States prior to the expiration of the 6 months after some vacation in Mexico. So, of course, because the expiration of the I-94 was coming up in 5 days, so he was strongly advised to leave in the 5 days.
Oh, okay, but that's not what I understand your explanation, but that's not what this question says. Maybe.
He filed 2 days after.
Yeah, for as long as he applied before the expiration of the I-94, he should be fine. I mean, that's the law. Even if the CBP officer advised him to leave in 5 days, for as long as his petition was submitted before the expiration, he complies with the law. He should be fine. That's not. I mean, I've seen people who are granted. Maybe Marisa will remember this. People who are granted like maybe 1 week entry I-94, and then we quickly apply for an extension. Of course, you can still do. You can still, and I've also seen people. I remember when CBP officer they used to stamp passport and say that you cannot change your status or you cannot.
Yes.
They will stamp it on passport. We still went ahead to change status because there is no law that is violated if you change your status.
No, remember that sometimes they're also told, oh, you have 1 week to stay, and then you go online and check the I-94, and it actually shows for 6 months.
Yes, sometimes the officer tell you something verbally that is inconsistent with what they have in their record. That's another possibility. So this person should probably check the I-94 upon re-entry to see if a new I-94 was issued. But assuming that it was not even issued within the 5 days, if he apply for adjustment or change of status before the expiration of the 5 days, it will still be fine. You just need to be sure that the application is received by USCIS before that 5 days, not that it's mailed out, but it must be received before that 5 days. The next one. Good day, doctor, and thank you for all you do. Sir, in December 2023, I filed a Vawa with overwhelming evidence. My priority date was August 2022 because I have an approved I-130. Please, when do you think I should expect adjudication? Well, Vawa is not even one of those applications that are affected by visa availability. So priority date or no priority date is completely irrelevant. So what determines the adjudication is simply the workload. It is the workload. And right now, the current visa bulletin, do they even list Vawa in there? Can you please check? They are not. Please confirm. I don't think they are, but let's just confirm. So this is not one of those things that are affected by priority date. So it's just a matter of how much application. Yeah, because one thing you also need to know is that VAWA is only processed in one single office in the United States, and that office is in Vermont. So only one office process VAWA in the United States. So the adjudication is taking a lot of time because of the workload. So what affects it is the workload, not priority date.
Is that same department in charge of, or that same service center in charge of reviewing the approved VAWAs, the ones that were supposed to be revised? Is that same? Remember how the president mentioned that for VAWA they're gonna put special attention because people.
Yeah, it is still the same office. It is still the same office that is. So they have more work to do. Yes, but I also know that they, because of the big beautiful bill, they are hiring more hands. Okay, let's go to the next question while you are checking.
It's not. I mean, on EB4 it says just
No.
special
We are
non-immigrants.
talking about processing time. Processing time.
You said visa bulletin.
No, I was telling him that visa bulletin, this does not affect visa bulletin.
Okay.
Because his question is to determine how long or what is the time frame.
I also misunderstood you.
Yeah, it is the processing time that I want you to check. Okay, while waiting for that, let me quickly answer the next question. I was in USA in 2024 on J2 visa and applied for EB2 NIW in April 2024. Up till now, my application is still under processing. Meanwhile, I left USA in January 2025. Is there hope for approval? EB I-140 has nothing to do with your location. It has nothing to do with whether you are in the US or you are outside the US. It is purely a petition. It doesn't affect approval. Approval is entirely based on eligibility. So if you are eligible and your petition is already approved, you will just process it through the consulate. And because you already left the United States, you probably will not face the challenge of 2-year foreign residency requirement. So it doesn't affect it. It's as simple as that.
43 months.
Okay, for the VAWA question, the processing time is currently 43 months. And I think that question says he filed it in 2024. So.
It said he filed in 2020.
So if you are talking about 40.
December 2023.
Yeah, it was.
So if you are talking about
He said
43
his
months,
priority date was 2022.
12 months is 1 year, 24 months is 2 years, 36 months is 3 years, so 43 months is almost 4 years. So it's still a lot of waiting to do. So this is not about priority date or visa bulletin. It is simply because of workload. Okay, so this one, I already answered the J1 question. Let's go to the next one. Sir, my I-130 spousal application was withdrawn by my spouse. USCIS gave me 33 days to leave in 2020. Otherwise, I will be issued a notice to appear. I was not sent any notice to appear until I left. Is there a continuation? US in 2021. I had an arrest for violating restraining order in 2020. Case dismissed. I was exonerated in 2021. I'm now a permanent resident in Canada. Do I have a ban? Is it safe to apply for a visa to US now? Again, I'm going to advise this person to go to EOIR portal. Go on Google, EOIR case portal, case status portal. Search it, put in your alien number. If you have a removal order, you will see it there. Because it is possible, I'm not saying it is certain, but it is possible that even after you left, you may have been issued a notice to appear. And if you have been issued a notice to appear, if you are required to appear in court and you didn't appear, you may have been ordered removed in absentia. However, if on the other hand, you didn't, you were not placed in removal proceedings, what I will advise you to do, two things I will advise you to do. Number one, find a way to make yourself known to the US authorities that you live in Canada. How do you do that? You can apply for a visiting visa to come to the US. Even if they deny it, they will know that you attended an interview in Canada, you are physically present in Canada. Or in the alternative, there is a form, I can't remember the name of the number of the form. There is a form that when people depart the US, they fill that form and they take it to the US embassy in the country where they are in.
Is that the one they use after voluntary departure?
Yes, for them to verify that you are physically out of the United States. I can't remember the name of the form. If you can help me check it, please. So, if you have that form, you can fill that form and go to the US embassy in Canada, any of the US embassies in Canada, go there and tell them to sign the form for you. The form only verify that, okay, we confirm that this person is physically here, so that they know that you actually departed the United States when you are supposed to. The second advice that I'm going to give you is that wait until you become a Canadian citizen. I don't know how long it takes someone to become a citizen in Canada, but wait until after you become a citizen in Canada before coming to the US, because as a Canadian citizen, you don't need visa to enter the US. So wait until that time rather than create any additional complication for yourself. So that will be my advice. But either you want to wait or not, the first thing you need to do is to find a way to let the US government know that you are not in the United States. And the easiest way to do that is to fill that form. Did you find out the form number?
Well, they're mentioning something.
I can't remember. It's been a lot.
210, notice of action, voluntary departure. But I think that's the one given by the court.
No, this one is not given by the court. It's
Okay.
online.
Okay, I-392, notice of departure of alien under voluntary departure.
Okay, I-392. So search it on Google, form I-392. Fill that form, take it physically to any US embassy in Canada for them to verify your physical presence in Canada. So once you do that, and you'll be fine. But again, wait until you become a Canadian citizen so that you do not need to apply for visa to come to the United States. Yes, notification of departure. Yes, that's it. That's it. Yeah, from I-292, notification of departure. Yes. So
Although it says here that the one that prepares it is the officer, not the individual.
Yes, take it to the U.S. embassy. If the officer need to sign it, all they just need to verify is that this person is physically here. You can't be physically out of the U.S. and be in the U.S. at the same time. So that will show that you left. So that even if there is a removal order after your departure, it will still show that you have been outside the country.
How many more questions?
Okay. Did you not put a mark?
No, we
When
did
I,
that earlier. And then you've answered 4 questions after that?
Let me see. I think so.
Okay, this is 154. Wherever I am, but in the next 2 minutes,
two?
that would in the next 6 minutes, that would take us to 2 hours. So wherever I am, I will stop. This didn't start. Is it for a period? Okay, is that the beginning of the question? Okay, for a period of 6 months in a year, I have done my biometrics and I have been scheduled for interview for October 15. Will you advise that I go for the interview? Should I not go for the interview? What kind of interview? I don't know. Is this based on what?
They didn't explain.
Are you sure that's the beginning of the question?
Yeah. I just checked the ones prior.
Yeah, so I don't know what the interview is all about. Is this family-based interview? Is it asylum-based interviews? I mean, people don't expect too much from me because I don't know exactly what you have in your mind if the questions are not clear. So I don't know what kind of interviews. It's difficult to advise whether to go or not to go.
Consequences if I abandon the application, but nothing else.
Again, what type of application? For example, if it's an asylum application, whether you show up for interview or not will not prevent them from sending you to removal proceedings. So it depends on the application. So what type of application? And even under this current administration, one of the
That's not the beginning. It's an N400. But I don't see the question before this one. Do you see it?
No,
look at the name of the applicant.
Yeah,
we
it's
have.
not there.
there's not one there.
It's not there.
I do not see one.
It didn't post. But she's saying it's naturalization, N400. She just sent the question right now. She just sent the follow-up information.
Well, what I wanted to say is that one of the executive orders signed by the president during this administration that talks about issuing NTA for all denied application.
Even N400s?
That is where I want to talk about. My advice, I don't know on what basis this person is fearful. If this is based on maybe the green card was obtained based on marriage. If immigration have evidence that the marriage is not legit, if they deny the N400, they can actually place the applicant in removal proceedings. We have had clients that had that done to them. So if they in fact multiple clients, if they deny it, they can actually place the applicant in removal proceedings. Mm-hmm. So for that reason, again, you also have to balance it between attending the interview and creating more evidence for them to use against you. So you have to balance it depending on the fact of each case. But rather than abandon it, I think it will be better to withdraw it. If you send in a letter withdrawing your application, you will not have anything pending. But if you abandon it, they may still go ahead and adjudicate it in your presence, in which case they can still deny it if they have enough evidence to believe that the marriage is fraud and then place you in removal proceedings. So
remember what happened to that other person too? I think she decided to withdraw, but before then she got a call, and the answers that she provided over the phone, they used it to adjudicate it and still deny it, even though.
That is why I'm saying that, yes, you don't want to incriminate yourself. So it may be better to just send in a letter. I wish to withdraw my application for naturalization at this time. I intend to reapply in the future. Simple. You don't have to provide any reason. You don't have to do anything. If they call you over the phone, you are not obligated to provide any information. Like I said, this is a country where we have the right to not incriminate ourselves. Even if they introduce themselves as immigration officers, you still have your right to determine whether you want to answer their questions or not. So don't provide any incriminating answer or anything. Send in a letter withdrawing your application, but don't just leave it, because if you just leave it, abandon it, they will continue to adjudicate it. They will continue to conduct investigations. They will continue action on the case. But if you withdraw it, then you are effectively stopping whatever they are doing on the application, maybe until you reapply in the future, probably under a new administration. So the next question. Okay, thanks for all you do, Dr. Asekun. You're welcome. My daughter's EAD was approved since December, but we are yet to get it. Service requests have been raised a couple of times. Kindly advise. Do you have a lawyer? Because sometimes they may have sent it to your lawyer instead of sending it to you. But assuming, because one thing, sometimes what I know immigration that they do all the time is that whenever your application, whenever an EAD was mailed out, if it was not returned to USCIS, they will not produce a new one. If it was not returned, they will not produce a new one. It may also be that the EAD has not been produced at all, because immigration is very inconsistent. We have seen cases that were approved and then the card was produced within a week. We have also seen a case that was approved and the card was not produced in 3 months. Even more than that. I mean, so they are very, very inconsistent. But the first thing I want you to do, if there is a way to get a tracking number, because sometimes when they mail it out, they provide tracking address. Sometimes they don't. Again, they are very inconsistent. But try to, if you have an account, log into the account and try to get, find out if there is a tracking number. If there is none, call USCIS, tell them you have not received it, find out if they can confirm if the card has been mailed out. If they told you it's been mailed out, find out what is the zip code of the address where it was mailed to. And then the other option, you have already done service request. If all of this fail, you might also want to consider congressional intervention. That is all I can say, and it's already past 2. We have been on this now for 2 hours, and I think I'm going to stop at this time. We hope to continue against next week. Hopefully next week we will have enough time to answer more questions. Until then, I remain yours truly, Dr. Olu Asekun. Stay out of trouble, and also remember me in your prayers. You know, this thing we are doing, sometimes we face a lot of challenges, but we will continue to do it. Also, remember to subscribe, and remember to also follow us on other social media. We are on TikTok, we are on Facebook, Instagram, all of them. X. So remember to join us. Until then, I hope to see you again next week. This is yours truly, Dr. Olu Asekun. Stay out of trouble.